I wish to speak on the first reading of the Criminal Procedure Reform and Modernisation Bill, and I want to comment on a couple of points that have been made. And one is that the size of a bill isn't the measure of the depth of its application, or whether it is in fact going to make a significant difference to the way things are done. So I could point to legislation that is large in size but not great in impact, and there have been many examples of that. So I don't think that we should be taken with the fact that this has got some 500 and something pages, which I'm very pleased the previous speaker has read every page of. I'm not on the Justice and Law Electoral Select Committee, so I don't get the pleasure of going through it with a fine tooth comb. But I've got far too much fixing up the botch-ups on the bills that get referred to commerce, so there you go. The Financial Markets Authority's just got a little bit. Well, we might find some difficulty, but I'm sure the Speaker won't want us discussing another bill in this debate on the Criminal Procedure Bill. What I want to particularly focus on is the question of name suppression, and this does propose some changes, probably not particularly changes of substance, because of course the law already allows precedent has been established through the court system to allow for a threshold to apply against the presumption that suppression won't be granted. So, and that threshold seems to operate quite universally within the higher jurisdictions, but it appears that there seems to be some discussion as to whether the question around suppression is being appropriately applied at the lower level. I think this is an incredibly important issue, and it was interesting going back to the Law Commission report on suppressing names and evidence, because everybody who submitted on this report actually agreed with the starting point, which was that we start with the presumption against the suppression of evidence. And so essentially they were basically arguing that the principle of open justice and the right to freedom of expression have been described as rights that go to the very existence and health of our political and legal institutions, and everyone accepted that every single one of the people that submitted on this agreed with the starting point that it should be suppression should not be granted. But I mean, somewhere deep down inside of me, I kind of don't know whether that's still should be the case in a society where we have instantaneous communication, where that rule wasn't developed in that environment at all, and that was about having courts open and people to be able to freely come and go and observe the processes of justice. Nowadays, we have people convicted before they've even had a trial. They're convicted in the public opinion, in the court of public opinion, before the case even starts. And that bothers me. It really does bother me. And I actually wonder whether this is not a good time to actually reflect on the history of why we've ended up with this presumption operating the other way. Because if we're operating from another fundamental principle, which is that people are innocent until proven guilty, then surely that the protection should exist around that presumption as a primary protection, and maybe this question around suppression is actually more about consistency than it is about openness. And maybe the consistency should be the other way around, which is that the presumption is that suppression is always granted unless there's a very good reason not to. And I want to just explore this, because I know of a case in Christchurch where I think it was a travesty of justice in terms of what actually occurred. But it was a case where name suppression had been granted against a male, I think in his 40s, It was a charge that he was facing. It related to an entrapment case where a police officer had brought a 14-year-old posing as a daughter and to make this 14-year-old available for a sexual transaction, which of course would be illegal on every level. But in fact, nothing happened, but a transaction was going to be entered into and he was charged with this offence. Name suppression was granted. There was all sorts of murkiness around the entrapment issue, so it was going to be a very difficult issue. There followed a sequence of, or a series of appearances on the Home Show, essentially of males in their 40s holding high-profile positions, which actually looked like free advertising to me and probably was advised by a certain consultant who just seemed to be the same consultant advising all of them, that they all came out and said, "It's not me. It's not me." Every single one of them appeared on the television saying, "It's not me." And when the case went back to the court for a review of the suppression order, in fact, the judge, I felt, was put under enormous public pressure to lift the suppression order because suspicion was being cast upon so many. And I think that that was because there is this essential presumption that names will be put there in the media and that somehow we have the right to know who's being charged, when in actual fact we actually have the right to know who's been convicted. And there are only very exceptional cases where name suppression would apply in a case after a conviction, and they really are around the rights of victims. So I know that that's not the view that has been adopted, but I would really like us to take the opportunity to reflect on whose rights are we really protecting and what rights are we really protecting with this debate on name suppression, because sometimes I think we forget that our technology has moved on beyond those who wrote those original rules by which we operate today. Now, I know that the Minister has taken some considerable effort on this issue, because there is the wider issue about what can't be suppressed in an environment which has changed as well. And so maybe my plea is one that's too late, because there is no mechanism for protecting that information in the internet age. And I won't describe what Whale Oil calls the Minister, because I know what the acronym stands for, and it would be totally unparliamentary for me to mention it.
And who cares what he says anyway?
No, well, I actually don't normally read Whale Oil. I make a point not to. But it does tie up with all of this, because I think the issue around suppression can't be separated from the issue about how now access to information is so open. And the Minister's conducted, really alongside these changes in our law, a Law Commission review around the adequacy of regulations around how the internet interacts with the justice system. And I want to support the concept of having that review, but I also at the same time want to acknowledge how hard it will be, because the two media jurisdictions that we have at the moment, Broadcasting Standards and Press Council, which give us, those who read or view the news, it is us who have the right to have matters presented with fairness, accuracy and balance. We're not going to get that from Whale Oil. We wouldn't expect it from Whale Oil. In fact, he wouldn't be Whale Oil if there was any fairness, accuracy or balance in anything he said. And actually, when you think about what a blogger does... No, but seriously, when you I'm being serious. When you think about what a blogger actually does, you wouldn't expect fairness or balance. But accuracy, I think, is not an unreasonable thing to expect. when somebody knows that they're deliberately misrepresenting the situation in order to make a particular point. So I will look forward to this bill going to a select committee that I'm not on, and I will look forward to hearing from my colleagues who are on the select committee the debate that goes on within that, and I do encourage people to make submissions on all of the detailed issues that are contained in this bill.
Dr. Kennedy Graham.
Thank you, Mr. Speaker. I actually do have